Amazon sellers, I'm going to give you our top 5 arguments to the court when your assets are frozen under a temporary restraining order. Okay, Amazon sellers, as far as I'm aware, me and my awesome team handle more temporary restraining orders that are issued against Amazon sellers than any firm in the world. And what I'm going to outline for you today are the top 5 reasons we argued to the court why the order issued against you, why the order freezing your money, freezing your sales on Amazon, freezing your inventory, why the court should dissolve that order and let you get back into business. So starting with number 5, simply responding to the lawsuit makes you vastly different than most other defendants out there. You'd be stunned to learn how many Amazon sellers simply don't respond to the court, and by you responding, you stand out as someone who's not running and hiding. You are here to fight it out because you did nothing wrong. Number 4, the bond is insufficient. What do I mean by that? Well, when a law firm for a brand goes into court and asks the court to issue an order freezing other businesses' assets, whether it's like 1 to 10 or hundreds of different businesses at a time, the court will almost always require the plaintiff, the company bringing the lawsuit, to post a bond. And in every case that we have seen, the bond has been insufficient. We've seen the court require $5,000 bonds when our client was losing $35,000 a day. Number 3, we go into court and we ask the court to release our clients from the temporary restraining orders because the allegations, the products at issue, are only a small portion of our client's business, yet the court has frozen absolutely everything. So let me give you an example. We had a seller where the allegedly, not the proven, but the allegedly infringing products were less than 3% of our client's sales. Yet the court froze 100% of the assets, 100% of the sales, and 100% of our client's money. And this is a very, very effective argument to go to court and say, Your Honor, you gotta unfreeze this business because even if the allegations are true, it's only this much of the business and you have frozen the entire thing. Number 2, and this is gonna sound kind of silly, many of these lawsuits claim that all of the sellers who are being sued are part of a vast Chinese conspiracy. Now, vast conspiracies are like something from the 80s or the 90s when Clinton was president and Hillary got up there and said it was a right-wing conspiracy. These allegations are still going on. And I'm not getting into politics with you, but I can't tell you how many lawsuits we've seen where the allegations against US-based sellers, against sellers located in the UK and other parts of the world, are accused of being part of a vast Chinese conspiracy. This argument is super effective because you are not part of a vast Chinese conspiracy if you're not located in China. Last but not least, number 1, no risk of irreparable harm. Before a court issues an order freezing your money and your assets and your business, it must have been persuaded by the brand who brought the case that unless the court does something right now before you even have a chance to respond, there will be irreparable harm that cannot be fixed. And we go into court and we persuade the judges that issue these orders that this is just utter nonsense, that the brand who brought the litigation was in the same position before they came to court, the same position during the court case, and they will be in the same position after court is over. And therefore, there is no irreparable harm. If there are any damages, a check or a payment of money will suffice, and therefore the court should dissolve the temporary restraining order that it was wrongfully persuaded to issue. So those are the top 5 arguments that we make when you are sued and your assets are frozen. 5, you are responding. 4, the bond is insufficient. 3, the allegedly infringing products are only a small part of your business. Number 2, you are not part of a vast Chinese conspiracy, and number one, the brand will not be harmed irreparably, and they don't need and they are not entitled to freeze all of your assets.